So thank you all for joining us today for our presentation on the Extraordinary Ability Visas. My name is Dustin Saldarriaga, and I'm a Senior Associate with Scott Legal PC here in New York City. We are very fortunate to have today joining me my fellow Senior Associate, Jiyae Hwang. Jiyae has extensive experience preparing Extraordinary Ability Visa petitions. So is able to draw from that experience. So is here to share some really great insights with you all throughout this presentation. A few housekeeping items before we get started. This webinar is part of a series. We, at this point, are doing, I believe, at least one webinar a week, and those run the full spectrum of U.S. immigration law. So we do at our firm prepare petitions not only for business-related visas, but also family-based petitions, as well as temporary visas such as student visas, visitor visas, really the full spectrum of U.S. immigration. So if you do have any questions about anything related to U.S. immigration, we do hope that you'll reach out and contact us. Those webinars that we present do cover the full range of immigration topics. After this presentation, you'll be receiving an email that has a link where you can sign up for those webinars, as well as a link to our YouTube channel. We do record all of our webinars. We post the full-length recordings to our YouTube channel. We do hope you'll check that out. Our YouTube channel also has shorter videos where, again, we touch on a variety of immigration topics, and we're really proud to make available to you all free content that we do consider to be the highest quality content on U.S. immigration on YouTube, on the internet. We have a very active blog as well. You'll be able to access that at our firm's website. So please do take advantage of those resources. After this presentation, you will also be receiving the PowerPoint that you see on your screen, so no need to take extensive notes. And you'll receive our contact information, of course, where if you do have questions about your specific circumstances, we do hope you'll schedule a consultation where we can get into the details of your circumstances and answer any questions you have and help map out what may be the best route for you to take given your goals and circumstances. If you have a question during this presentation, please do send it in using either the chat function on Zoom or the Q&A function on Zoom. We will be monitoring those throughout the presentation. We will likely be saving all questions for the end, but we do plan to get to all of them, so don't hesitate to reach out and share those with us. So without further ado, I will go ahead and pass it off to Jiyae.
Thank you, Dustin, and thanks everyone for joining us today. So let's start with an overview of the Extraordinary Ability visa categories. So we will be covering the EB-1 green card, the O-1 visa, and also the EB-2 NIW in this presentation today. And the EB-2 NIW also does have significant overlap with the Extraordinary Ability visas, even though the NIW is technically not an Extraordinary Ability visa. All right, so let's then start with the O visa categories. So the O-1 visa, generally speaking, is a non-immigrant visa that is available for individuals who can show that they have an extraordinary ability in their field. And the O-1A visa and the O-1B visa are subcategories in the general O-1 visa category, and the O-1A visa is for the fields of the sciences, education, business, or athletics, and the O-1B visa is for individuals who are either in the arts, defined as the creative arts, or the motion picture or television industry, which is, film, movies, and the like. So the O-1A visa and the O-1B visa are different in terms of what fields they cover in the industry. So the O-1A visa is the non-immigrant visa that you would apply for if you are someone who is in the sciences, education, business, or athletics. And the standard to meet for extraordinary ability in these fields are you have to show that you're one of the small percentage who have risen to the very top of the field in your profession. And that is typically shown by showing you have received national or international acclaim. So you do need to show that you're very well known, and that there is, enough documentary evidence showing that you have earned that recognition as a top player in your industry. The O1B visa has a slightly different definition of what it means to show extraordinary ability. So, with regards to the arts, if you're someone who is in the creative arts, you must show that you have received distinction, which is defined as a high level of achievement as evidenced by a degree or skill and recognition that is substantially above what is ordinarily encountered in the field, to the extent that you can be described as prominent, leading, or well known in the field of your particular creative industry. And you can see that the definition of extraordinary ability is a little different from what we just saw in the O1A context. In the O1A context, you were looking at the small percentage who have risen to the very top of your field. But in the O1B arts context, in the creative arts context, you just need to show distinction, a level of acclaim that is substantially above what is ordinarily encountered. So you can see that the level of acclaim that they're looking for is slightly different. Now let's look at the standard for the motion picture and television industry as well. And in order to count as somebody who has extraordinary ability in the motion picture or television industry, what they're looking for is a level of acclaim that is substantially above that of your peers. Substantially above your peers. So basically, someone who is well known and prominent, not just the ordinary level of acclaim, but you need to show that you've earned some sort of distinction comparatively that shows that you are somebody who is a distinguished actor, a professional in that particular industry. All right, so let's move on to the next slide. So the EB-1A and the EB-2 NIW are green card categories. And as you may already know, the O1, when we speak of the O1 visa, they are temporary visas. So you don't get to, live permanently in the United States on a temporary non-immigrant visa, but the EB-1A and EB-2 NIW are green card pathways. So if you qualify under those channels, what you get, the benefit that you get is a green card. Basically, you would get the right to permanently live and work in the United States. You can work for any employer that you want. If once you get the green card. So you do get that freedom. Now, having a green card comes with responsibilities as well. So one advantage of having, the O1, which is temporary visa, which is that you don't have, this minimum, period that you need to stay in the United States, right? And you can travel outside and stay as long in your home country as you want, because, the temporary visa is more suited for that. By contrast, if your intent is to live and work permanently in the United States, and if that's going to be your permanent and primary residence, then the green card would fit your purposes better. So the EB-1A and EB-2 NIW are green card pathways that opens up those kinds of possibilities for you. Now, in order to qualify for the EB-1A extraordinary ability green card, you need to show that you have extraordinary ability in any field. So although the O1 was divided into O1A and O1B, for the EB-1A, it's basically one category for all fields. So it is one standard that applies for any field. In the sciences, arts, education, business, or athletics, you will still need to meet that one threshold. So the standard is that you need to show that you're one of the small percentage who have risen to the very top of your field of endeavor. And you show that by showing that you have sustained a national or international level of acclaim, and that your achievements have been recognized broadly in your field of expertise. And it is important to note that the EB-1A is a very, very highly discretionary and highly what do you call it? Highly scrutinized category. It is really the first preference category of among the green card categories. And so when the USCIS is looking at EB-1A petitions, they look at every single evidence very, very carefully. And it is important to show not only a high volume of evidence of your recognition in the industry, but also make sure that the evidence that you are submitting are relevant and high quality and strong in terms of really being exactly what the criteria is looking for. So the EB1A is kind of a category where if you feel like a piece of evidence is kind of a stretch, right? So for example, let me give you an example. If you're trying to prove that you and your work have been featured in major media, but what if you're trying to say that you being, mentioned in a very small industry blog, what if you're trying to prove that that is, that counts as major media? That could be a stretch. And in the EB1A context, if a lot of your evidence is not, the quintessential or kind of, persuasively responsive to the evidentiary criteria, you will get a lot of pushback. You will get USCIS who's looking at the evidence with a very scrutinizing eye and think, hey, we need more proof that this particular industry blog is major media. We want to see what the circulation of this industry blog is. We want to see, more proof that this industry blog is actually a major media. So that is one example to say that the EB-1A green card is one of the toughest categories to be approved for, which is definitely the reason why you want to be very strategic with the evidence that you present and how to present the evidence. And really, you really want an experienced lawyer to look at your file and to, provide you with guidance on how to, amplify your strengths and, really provide the substantial support that the USCIS will be looking for when you're submitting this file. So definitely the EB1A is not about just ticking boxes, and that can be a misconception, right? That as long as you tick particular boxes, you can automatically qualify for a green card. Unfortunately, for the EB1A, that is not the case. It is very highly fact specific, and you do have the burden of persuasion to persuade the USCIS that the volume of evidence that you provide really shows that you are a front runner in the field, and that the strategy there can differ based on the facts. Now, the EB2 NIW is called the National Interest Waiver Green Card Pathway, and it is slightly different. As opposed to the EB1A, the EB2 NIW has a degree requirement. So you either need to show that you have an advanced degree, which is defined as a master's degree or above in your field. And that can also be proven by showing that you have a bachelor's degree in your field and 5 or more years of progressive work experience in your field. Or you can also prove that you have exceptional ability in your field to qualify for the EB2 threshold criteria. But the important thing about the EB2 NIW is that you also need to prove why you merit an NIW. So the advantage of the NIW is that you're exempt from the ordinary requirements of having a US company sponsor you for the green card. So the larger category of EB2 cases is that you would typically get a job offer from a US company, and the US company would go through what is called a labor certification process. And only when the US company can show that there is no other US person who is minimally qualified to take your job, then the US company would be able to sponsor the person for a green card. But if you can show that, you meet the qualifications for an EB2 NIW, you are exempt from that requirement. So basically, the EB2 NIW allows the foreign national to self-petition for the green card. Similar to the EB1A green card, where the EB1A beneficiary can also self-petition for a green card, there is no job offer requirement. In order to, apply for a green card. If you qualify under the EB2 NIW, you don't need a US job offer. You can just move forward with a self-petition. Now, there can be some overlap with EB2 NIW applicants and EB1A applicants because one of the ways that the government looks at, you know, national importance in the EB2 NIW standard is whether somebody's work has the potential to impact the field and contribute to advancing the field in a broad way. And if a person can show that they have already influenced their field in a major way, right? By, if this person is a scientist, right? If they, you know, develop new technology that has been highly cited or, you know, incited a lot of follow-on research, things like that. If you can show that you have influence, if you had influence and impact in your field before, then that can have a lot of traction on, trying to show that your future work in the US will be as impactful and also that you're well positioned to, advance that endeavor that can really make, a broad impact and bring broad benefits to the United States, help make the US industry more competitive and things like that. So there can be a lot of overlap with the extraordinary ability candidate pool. So this can also be a good option to consider, depending on what you're doing in the United States and depending on how you can persuasively tie that in with matters of national interest. And and Dustin will go over the details of the qualifications that you need to prove for the EB2 NIW in later slides. All right. So now let's go into a little bit further detail regarding the requirements to qualify for each of the visa categories. So let's start with the O-1A visa requirements. What will I need to demonstrate? So either you would prove that you have received a major internationally recognized award, or the other way to qualify is to show that the beneficiary meets at least 3 out of the following enumerated criteria. Now, the first way to qualify by proving a major internationally recognized award, it is very rare. And if you have such an award, such as a Nobel Prize or, a Pulitzer Prize, for example, if you're a journalist, things like that, you don't need to go through the other criteria and the 3 out of the requirement to prove the 3 criteria. You don't need to go through that if you do have a major award like the Nobel Prize, but because of the nature of such awards, it is very rare. And I would say 99% of the cases that we file, the beneficiary would try to prove at least 3 out of the enumerated criteria. So let's look at the enumerated criteria below, which is listed. So receipt of nationally or internationally recognized prizes or awards. And when we speak of awards here, we're not talking about that one-time major international award such as a Nobel Prize. Even if you have received a lesser prize that is lesser known than the Nobel Prize, you can potentially still meet the lesser criteria as one of the 3 criteria that you show that you meet. Membership in associations in your field which require outstanding achievements. And the important thing here is really the qualifying adjectives here, right? So you can't really qualify with any membership in any association, but what the government is looking for are your membership in associations that require outstanding achievements to gain membership. So if you can gain membership by just paying a fee, for example, right? Or just by having a particular degree, or just by, being part of a profession, right? So just a professional association for engineers, for example, that would not be enough to show that that is an association that requires outstanding membership, outstanding achievements of its members to gain admission. You will need to provide proof of what is the admission criteria for getting that particular tier of membership, in order to prove that there is that discretionary factor that is required for membership. Publish material in professional or major trade publications, newspapers, or other major media about you and your work in the field. So here, you do want to read the language carefully, right? What they're looking for are publications in major media. And the USCIS will want to look for supporting evidence of why that particular publication is a major publication. So, maybe a particular newspaper, right, is part of uh, part of a list of major news media that has been ranked in an independent media ranking website. Or maybe you have data about the circulation of a particular trade publication where you were featured, and you can cite those numbers to try to support that it is a major media source that featured you. But definitely, it is important to read all parts of the regulatory language and make sure that you're providing evidence on that is responsive to all of the conditions of the evidence that they're looking for. Original scientific, scholarly, or business-related contributions of major significance in the field. And this can include things like, developing new patents or processes, new technology, any innovation in the field that has really impacted the field, in advancing best practices or things like that. Really, this is a criteria where strategic advocacy can really help you. So if you have offered something to the field where the existing procedures or existing technology was deficient, but you brought something new to the field, commercialize a solution broadly that really solve that problem for the industry or the field, yeah, you can definitely try to make that case. And a large part of making a persuasive case for original contributions is with expert letters. So you want to make sure that you have very detailed, persuasive expert letters that describe what the problem was and what you did to solve this problem in the industry and how this has impacted the field. So you want to make sure that the expert letter is providing that narrative in a very clear and concrete way, instead of, being a very vague and template-based letter. More detailed and more concrete letters will do more to really persuade the USCIS that yes, this person has indeed made original contributions that has changed the field for the better. So strategy is very important in preparing evidence for that prong as well. Authorship of scholarly articles in professional journals or other major media in the field, high salary or other remuneration for services, participation on a panel as a judge of the work of others. All of those types of evidences can be counted as part of the 3 evidences that you can collect. Employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. And this criteria can also be a very useful and relevant criteria, especially for people like entrepreneurs, right? So if you're an entrepreneur, you've, played a critical role in founding a startup, you've played a leadership role, you're the CEO, for example, and maybe you can show that your startup has received a distinguished reputation in the industry. Maybe you can show that your startup was accepted into a world top accelerator like Techstars or Y Combinator, right? Maybe that can be part of a distinguished reputation, right? So also remember that there are 2 parts to this criterion, right? The first part is that showing that you yourself have played an important role in that organization. And the other part is proving that that organization has a distinguished reputation. So you do need to have evidence supporting both elements of this criteria. So as you can see, meeting one criteria, even in this list, is not a very simple endeavor. You do need to make sure that you're hitting all the right points, and a lawyer can definitely help you guide you through that process. All right, so now let's move on to the O-1B visa. Similarly to how it was with the O1A, you can either show that you have been nominated for or received a significant national or internationally recognized award in the particular field, such as, an Emmy or a Grammy. So here we're talking about a very, very, prominent award that's really the definitive award in an industry, or you can go, to the more, common way of proving eligibility, which is to show at least three out of the enumerated criteria below. So similarly to the O&A, there is a list of the type of evidences that you can collect and present as part of the three. Having been and will be performing in a lead or starring role in productions or events which have a distinguished reputation. So similarly to what we were talking about in the O&A context, not only do you need to show that your role will be lead or starring, you also need to prove that the productions have a distinguished reputation, and that must be supported by sufficient evidence like critical reviews or press releases or other forms of recognition. Publish material about you in professional or major trade publications or major media is another evidentiary criteria, which also show that you have received national or international recognition for your achievements. Similarly to what we talked about in the O1A context, if the beneficiary has performed and will perform in a lead, starring, or critical role for organizations or establishments that have a distinguished reputation, that can also be relevant as one of the evidentiary criteria. And we'll move on to the next page. Evidence of major commercial success in the performing arts, and that is really a criteria that is limited to the performing arts context, such as box office receipts or other sales metrics. Evidence of significant recognition for your achievements from organizations, government agencies, or other recognized experts in the field. And here, getting detailed and concrete letters from those leaders in the industry would be very important in meeting this criterion. Having commanded a high salary or other significantly high remuneration for services is also relevant, as it was in the O&A context. And other comparable evidence can be provided. However, for the motion picture industry context, you don't have the option to provide comparative evidence. One thing to know is that if you're going to show comparative evidence, you do need also to prove why that particular category of evidence is not relevant to your industry. So you do need to show backup for why this particular criterion is not relevant in order to be able to meet that criterion with comparable evidence. All right, so now let's do a little bit of a comparison between the O1A visa and the O1B visa. So please look at this table. The O1A visa and O1B visa are divided by the relevant fields. So individuals who are in the sciences, education, business, or athletics would go for the O1A visa. And the O1B visa is relevant for individuals who are in the creative arts or the motion picture or television industry. And when we speak of creative arts, right? So there are some cases where the case could go on either O1A or O1B category. So things like, if you are a tattoo artist, right? Maybe a tattoo artist can be seen as a business person, but also can be seen as an artist if you define tattoo art as a form of graphic art, right? So there can be a bit of room for advocacy on which category is really relevant for a particular field. So definitely, you want to talk to a lawyer, and the lawyer can help you strategize on whether to go for an O1A or an O1B. In many cases, going for an O1B, if there is a good case for that, may be advantageous because, as we talked about in the previous slides, the standard to qualify as an individual of extraordinary ability is a little bit lower for the O1B visa. As we discussed, for the O1A visa, the standard to qualify as an individual as extraordinary ability is to show that you're one of the small percentage who have risen to the very top of your field of endeavor. by having had national or international acclaim. Now, for the arts, right, for the O-1B visa, you just need to show that you've attained a high level of achievement as evidenced by a degree or skill that and recognition that is substantially above what is ordinarily encountered in the field. So the level that they're looking for is distinction. For the motion picture and television industry, similarly, they're looking for someone who has attained a level of acclaim that is substantially above his or her peers. So, a relative level of distinguished nature and well-known status is what they're looking for, as opposed to being the small percentage who is at the very, very top of their field. Now let's talk about how long the visa is typically issued. For the initial visa, it's the same for the O-1A and O-1B. You would be granted 3 years. And for extensions, it depends on whether the extension is based on the same project that was same project and same itinerary that was submitted for the initial. So if it's just an extension for additional time to complete the initial set of itinerary, then you will get an extension of 1 year each. But if it is a new set of projects, right, and if it is a new itinerary with, different events than the ones that you applied for last time, then you can get a 3 year extension on the renewal visa as well. So that part, that will really depend on the facts as well. Can your family come to the United States? So the answer is yes. The O3 visa is available for your spouse and minor children unmarried, under 21. They can accompany the O1 beneficiary on an O3 visa. However, one thing to note is that no work authorization is available for O3 spouses. However, it is possible for O3 dependents to go to school in the United States if they wanted to while they're accompanying the O1 principal. But unfortunately, work authorization is not available, so the O3 spouse cannot work while they are accompanying the O1 beneficiary in the United States. All right. So now let's talk about the EB-1A green card channel. So as we mentioned before, the EB-1A is the first preference green card category for individuals of extraordinary ability. And this is a category where someone can self-petition for a green card, as opposed to requiring a U.S. employer to act as the petitioner and sponsor. So the standard of extraordinary ability to qualify for this green card is very high. And let's see the evidentiary criteria that it is required to meet this stringent standard. So at least 3 out of the following evidentiary criteria you must meet. And the language really mirrors what we discussed in the O1A context. If you read through this, you can see that. However, one thing to note is that the quality and quantity of the evidence that USCIS will expect to see under these criteria is a lot different from the O1A context. So practically, USCIS will look at every single thing with a much stricter eye. And you will want to prepare a much more robust collection of evidence before trying for the EB-1A, even though the regulatory language is very similar. And one of the reasons why is because for the EB-1A context, USCIS does what is called a two-step Kazarian analysis, and we'll move on to the next slide to talk a little bit about that. So the Kazarian analysis. So in the Kazarian analysis, USCIS will basically look at your case in 2 steps. So the first step is the USCIS will look at the evidence to determine if you meet at least 3 out of the EB-1A criteria as we explained above. Now, similar in the O1 context, you can meet the EB-1A extraordinary ability criteria if you can show that you've won, the Nobel Prize, right? A major internationally recognized award that is really the prominent award in your industry. If you've won an Emmy, if you won a Grammy, like they're not going to look further than that. But for 99% of the cases, you would be trying to meet the extraordinary ability criteria the other way, which is to show at least 3 out of the EB-1A lesser criteria. However, the important thing in the Kazarian analysis is that there are 2 steps. So in the first step, the USCIS will look at whether you have provided enough evidence to, basically check 3 boxes, right? Have you provided evidence meeting the plain language definition of the 3 EB-1A criteria, at least 3 EB-1A criteria? And if you have done that, then it is not automatically an approval, right? USCIS will then go on to the second step of the Kazarian analysis, which is an analysis step that looks at all of the evidence in its totality. So in this particular step, USCIS will consider both the quality and the quantity of the evidence in totality, right? And really here it is a more subjective analysis on whether the totality of the evidence really paints a persuasive picture that this person is indeed someone who meets the regulatory definition, which is someone who has attained that level of distinction, has shown that they are indeed at the very small percentage of the people who have really been recognized in their field as having reached the very top. So one thing to note is that both the quantity and quality of the evidence is important. So let's say if you're meeting, the major media criterion, and if you show that you've, meet the major media criterion by, one article that's in kind of a lower ranking, kind of a regional newspaper, as opposed to having a feature story about you on Times Magazine, right? So even if on in the step 1 analysis, even if you can, show that you have provided some responsive evidence that is, arguably, responsive to the regulatory standard. In the step 2 analysis, USCIS will look at the quality of each evidence submitted, right? And in the example that I provided just now, right, being mentioned in, a lower, lower ranking newspaper maybe, and maybe having the article, describe your achievements in, 3 sentences, right? As opposed to having a full page feature story about you and your work in, the Times Magazine. Definitely you can see, the latter example of the evidence shows a stronger and persuasive case towards showing that this person has indeed reached that level of acclaim of someone who is a top player in their field. So that is to say that a lot of strategy is required when you're assembling an EB-1A package because it's not just checking boxes. Because of the Kazarian analysis, you need to make sure that the entire package of evidence is presented in a way that really persuasively makes the case that you have reached the top of the field through sufficient documentary evidence. So definitely both the volume and the quality of the evidence is important when you're assembling an EB-1A case.
Perfect. Thank you, Jiyae. So a couple of questions have come in that are related to the EB-1.
Yep,
And
we
the
can go
O-1.
through
So
that.
I think it's a good time to go through those. So the first, when you mention media and articles, should it be only media in the US or is media outside the US okay?
Media outside the US is okay. The important thing though is it must be major media. So major media as can be, proven by, national rankings. So we're not looking for media, even if it's foreign media, we're not looking for media that is really relevant to just a small localized audience. We're looking for more like national level media, right? But it doesn't have to be a US media to show that you've attained national or international acclaim. It can definitely be media from your home country. Well, it must be translated, right? But also, you must provide sufficient evidence proving why that particular media outlet is a major media outlet. Preferably, national level, national ranking media.
Perfect. And then when you're talking about scholarly articles, is there a certain number of citations that is deemed sufficient in general or no?
We don't really use a bright line citation count rule because EB-1A petitions are very, very fact specific, right? And citations numbers also differ by field, right? So maybe a world leading philosopher may have a smaller citation number just because there is, just because of the nature of the field, rather than, a scientist who may have thousands of citations, but maybe, that may just be what is normally, expected for a scientist. So really, it depends on the practice of the industry itself. And we typically want more than just the citations. And we would not just submit a Google Scholar and say that, hey, this is evidence of influence. That is almost never going to be enough context to show why this person has made a substantial, major original contribution in the field. We would want expert letters to describe why this was significant, right? And we would preferably have a volume of external evidence more than the citation numbers to show why this was significant. So there is no real bright line rule that the USCIS uses or that we use when we're preparing EB-1A petitions. Really, that is a fact-specific inquiry. And if you have other evidence that is outside of citations that show your influence, then it is definitely possible to rely on other types of evidence to show that you've made a significant original contribution in the field.
Perfect. And then last question, the Kazarian analysis, does that apply to the O-1 or only EB-1?
That is a very good question. So the Kazarian analysis is a case law that relates to the EB-1A context. And for the O-1, literally, technically, Kazarian should not apply, but in practice, USCIS, if you look at the USCIS policy manual, USCIS does a bit of a Kazarian-like analysis in O1 context as well. So even if you meet, three criteria, USCIS will also look at the totality of the evidence to see if the level of acclaim that the evidence provides actually meets, the regulatory definition of extraordinary ability as we defined it, which is someone who has, attained that level of acclaim as being someone who is at the top of the field in the O1A context and that level of distinction in the O1B context. USCIS will engage in that qualitative analysis as well, even though Kazarian is a case that was promulgated technically just for the EB1A.
Perfect. Excellent. So, we are going to go ahead and move on and focus on the national interest waiver that Jiyae mentioned before. And just as a reminder, this is an EB-2 green card. So what EB-2 means is employment-based. So it is an employment-based green card, and it's in the second preference category. So whereas EB-1 is employment-based first preference category, EB-2 is going to be second preference category. And there are two big categories of EB-2 green cards. One is the national interest waiver, which we're going to talk about today. The reason the NIW or national interest waiver is unique is that, as Jiyae explained, it allows you to bypass the labor certification process. So if you're applying for a national interest waiver, you are basically telling the government that the endeavor that you're pursuing in the US is of such substantial benefit and national importance that the government does not need to see whether anyone else is qualified and available for the job. So it saves a ton of time off of that process. Also, the NIW can allow self-petitioning. So if you're an entrepreneur, you can apply. One point I want to make just at the start is that it is possible and common, somewhat common, to apply for multiple green cards at the same time. In the context of what we're talking about today, EB-1s, NIWs, we do see this quite a bit. So, Jiyae is talking about how the Kazarian analysis can mean that even though you have what seems to be a very much approvable EB-1 case, USCIS could look at it, say, hey, you satisfy 5 of the criteria, but we still don't think you meet the EB-1 level. That can be extremely frustrating, obviously. It can seem very arbitrary, and sometimes we do see responses by the government that do seem quite arbitrary. So one thing that is possible is to say, I'm going to file an EB-1A, but I'm also going to file an NIW, which presumably would be easier to be approved for, just so that you have two shots at a green card. What some people will do is to say, I'll shoot for an EB-1A and I'll shoot for an EB-5, a job creation green card that requires a significant investment. That EB-5 does take longer. But hey, if the EB-1A is approved, great. You don't have to worry about the EB-5 and you'll have a quicker response. So I want to put that out there, that one of the things that we do as attorneys is we look at where you want to go in terms of where your goals are. So if your goal is a green card, if your goal is to be employed in a certain industry or by a certain employer, or to have your own business, we can look at the different pathways and not only say, well, this is probably the best pathway for you, but also if that pathway ends up being closed to you by USCIS, then we can have a fallback pathway for you. So that's an important aspect of what we're talking about today. So let's focus on the NIW. As Jiyae said, the NIW is an EB2, so it does have a threshold requirement. In order to apply for an EB2, national interest waiver, you do need either an advanced degree, meaning a master's degree or higher, or its equivalent, defined as a bachelor's degree with 5 years of post-baccalaureate experience, progressive experience in the profession, or you need to qualify as having exceptional ability. And what that means is that you meet at least 3 of the 7 criteria that are defined in the regulations. We have them on your screen here. So that means an academic record showing you have a degree, etc. Relating to your area of exceptional ability, letters documenting at least 10 years of experience in your occupation, a license could qualify, evidence that you've commanded a salary that's higher than average, that really does reflect the fact that you are of exceptional ability. Each of these we can go into more detail on. We just want to put it out there that there is an option if you do not actually have the degree, the advanced degree, or the bachelor's with progressive experience totaling 5 years, at least 5 years, that you can satisfy these criteria. So I do know there's a question on this, which is if I'm filing an NIW, I have 2 PhDs, do they need to choose extraordinary or advanced, or they'll automatically recognize it as advanced degree? So what we do in our applications is we have a kind of an introductory section of the petition that will say the threshold requirement is met by this applicant because they have 2 PhDs. And then we will include in the application proof that you have those degrees. So you would not need to just put it in the application and assume they'll know that. We would, what we do, spoon feed. We would make it very clear, this is how we're qualifying. It's an advanced degree, PhD, and here's proof at Exhibit A that this person has a PhD. So that's the threshold requirement. And it is important to keep those threshold requirements in mind because they are oftentimes ignored. A lot of the time, people will just focus on the requirements I'm about to share with you and forget that you do need to meet these threshold requirements to apply for a national interest waiver. So once you've met those threshold requirements, the NIW application is going to look at 3 main elements to see if you qualify. The first is that you as the applicant are coming to the United States to pursue a proposed endeavor that has both substantial merit and national importance. So that could mean, just to give you an example, doing research on something that is important for national security. Let's say you do research on laser systems, or on geolocation systems, or on AI even. We may make the argument that you are pursuing a national interest waiver in order to continue that research, which is of national importance and substantial merit. So that's the first piece, is focused on your endeavor. The second piece is showing that you are the ideal person to pursue that endeavor. So the first piece is focused on the endeavor. The second piece is focused on you as the applicant. So to show that you're the ideal person to pursue that endeavor, we would look at things like your track record, your resume. How have you done this work in the past? What institutions have you done this work for? Do you have expert letters from colleagues or from people who are completely independent that don't know you personally, but that do know your work, that can talk about how important your work is? Do you have any patents? Have you published articles? What intellectual property do you have? Um, so things like that that are really going to, again, focus on you as the applicant. So again, the first piece is going to be focused on the proposed endeavor and proving that it is of national importance and substantial merit. Ways that you can do that are, again, letters from experts. Oftentimes, and the government is actually explicit about this, letters from government officials can carry particular weight. So let's say you are focusing your research on geolocation devices. If you have a letter from the Department of Defense or or NASA, say whatever agency it is that would have oversight over your work. If they are willing to give you a letter, that can carry a lot of weight. Similarly, foundations, if there are foundations that have funded your work, venture capitalists, if there are venture capital firms that have funded your work, these are all things that you can use to point to the fact that your endeavor is of substantial merit and national importance. And this is the kind of thing where you want to think very broadly, both in terms of the proposed endeavor and showing how it is of substantial merit and national importance, as well as the fact that you are best positioned to pursue the endeavor. Think broadly. You want to advocate for yourself as best as you can. And oftentimes, you are the best person to know what evidence is out there showing these things. We as lawyers are not necessarily going to know that you've received venture capital funding, that you've received a grant from the government, that a government agency is willing to write a letter on your behalf. We would look to you as the client to brainstorm those things with us to come up with those pieces of evidence. The third piece to a national interest waiver, which I would say is not nearly as difficult to satisfy as the first two pieces, is that there must be a showing that on balance, it benefits the United States to waive the labor certification process. So in other words, again, the national interest waiver does not require that you advertise the job to US workers. Doesn't require that you test the labor market. So an NIW application technically does require that you convince the government that it's worthwhile for them to waive that requirement. The reason this requirement is less demanding than the other two is that it tends to follow automatically from the other two. In other words, if you prove that your endeavor is of national importance and substantial merit, and you prove that you are the ideal person to pursue that, then you make those arguments and it follows logically more often than not that the labor certification process is not appropriate in this situation. Now, one thing I do want to quickly say is there is one case that really provides the framework for a lot of what we're talking about here. It's called Matter of Dhanasar, Dhanasar, came out in around 2017, and it talks about a lot of what I'm saying regarding the NIW here. So if you are interested, check out Matter of Dhanasar. It does a great job of defining exactly what the government's looking for in these applications and how it thinks about them. So let's talk about expert opinion letters. Again, as Jiyae said, this is an important piece of the EB-1, the O-1, and the EB-2 NIW. So let's just walk through these bullet points. For certain types of petitions, including those I listed, it is a good idea to get expert letters from key people in the industry. So think about current employer, your past employers, government agencies, government officials, people at foundations, um, and also think about people who don't necessarily know you personally, but are familiar with your work. So that could be other professors at other institutions. It could be other people who are celebrated in the field and have won awards, people who presented at conferences that are aware of your work, saw you presenting on your work at conferences. You do want people who when someone who's completely unfamiliar with your field, such as a USCIS officer, when they read the letter and they read that person's qualifications, they say, okay, this is someone whose word I can trust, whose word has weight. Okay, so think about that. And if you have two people who are about the same, say one is a postdoc in a lab and the other is the professor in the lab, the professor's word is probably going to carry more weight. So it's important to think about that as well. And the person, of course, should be able to speak to your work specifically. They should, even if they don't know you personally, they should be familiar with your work where they're able to write a letter to say, look, I know what this person has done professionally. I know why it's substantial, why it's important, and I can talk about the specifics of that. All right. So which category should you apply for when we're talking about the EB-1, the O-1, the NIW? The two the biggest question to start with is, do you want to remain in the US permanently? Do you eventually want to pursue citizenship? Do you want that to be on the table? If you do want to remain in the US permanently, then a green card is going to be your best option. The green cards we've talked about today are the EB-1A and the EB-2 National Interest Waiver. If you are not ready to pursue a green card, and it's just not feasible, the O-1 is going to be a better fit. It's a temporary visa, can be renewed, as Jiyae talked about. It also has in general, a lower requirement. So it is in general easier to get an O-1. It's also typically faster than the green card process. So those are all things worth considering. Do you have a US employer, or do you want to apply as an entrepreneur where you are essentially, or your company is the petitioner? If you are an entrepreneur, then really any of the options we've talked about today do work. You can apply for an EB-1A or an NIW as an entrepreneur. You can apply as an O-1 or O-1A, O-1B. The O-1A, O-1B is going to be more difficult. So while it is possible to apply for it as an entrepreneur, as a self-petitioned application, it is more difficult than the EB-1A and NIW. One of the things that Danisar, the case I talked about, talks about is that the NIW can be specifically for entrepreneurs. So it's a very clear, well-trodden path for that, where for the O-1, it's less common. You do need to jump through a few hoops. And finally, family considerations. So as Jiyae mentioned, the O-1, the spouse and the children cannot work, they can study. Whereas with a green card, EB-1A, EB-2 NIW, the spouse and children can apply for work authorization and a travel permit. So they can travel and they can work and they can study in the US once that work permit is approved. And another topic that is very complicated, and I do recommend that you schedule a consultation if you have any questions about this, is what if I'm on a non-immigrant visa, an O-1, an E-2, whatever it is, and I want to move to a green card? A few things to keep in mind. The first is that even though the EB-1A and the O-1 are extraordinary ability, the standard is not the same. The EB-1A tends to be more difficult, more challenging than the O-1. All right, so do keep that in mind, that even though you've been approved for an O-1, it does not mean you'll be automatically approved for an EB-1A. The other issue, and the one that is typically most difficult for people to navigate, is timing. If you have or are applying for a non-immigrant visa, are looking to extend a non-immigrant visa, or are even traveling on a non-immigrant visa, and the government finds out that you have a pending green card application, it could complicate your renewal of the non-immigrant visa or even your travel on the non-immigrant visa. So you do need to be careful of that. Timing is really critical. Talk with a lawyer to make sure you're navigating that the right way. And finally, family. So do keep in mind that when a child reaches the age of 21, so in immigration law, a child is defined by someone under 21 years old. So as soon as the child reaches 21, they quote, age out of their dependent child status. So you really do need to be mindful of them aging out. Also, you want to make sure that they don't age out of the green card application. And that can get very complicated as well. So if you have a child who, is even 17, 16 years old, and you may be looking at a multi-year process for the green card, talk with a lawyer about navigating that correctly so the child does not age out and you preserve their ability to apply for the green card. And finally, we already talked about this. Are extraordinary ability categories available for entrepreneurs? So the answer is yes, they are. The EB-1, the O-1, and the NIW can be applied for by entrepreneurs. O-1 is going to be more difficult, but they are all options. So reach out to us with any questions. So I know we do have a question. Uh, so I believe it is asking about a related PhD. Could it be used to qualify for the EB-1A? I will just say schedule a consultation if you have questions about your specifics. Jiyae, I don't know if you had thoughts to add to that before we wrap up.
Yeah, well, the EB-1A doesn't have a degree requirement. So what you would look at instead is, do you meet at least three out of the, enumerated criteria that we talked about, right? Like can you show that you've made original contributions of major significance in your field? Can you show that you judge the work of others in your field? Can you show that your work, has been featured in major media or things like that? So that is, the same inquiry that we would do. Just because you have a PhD doesn't mean you'll automatically be approved for an EB-1A. Maybe the EB-2 NIW could be a better way. Definitely schedule a consultation with us, and we'll be able to advise you.
Perfect. Thank you, GA, for sharing your expertise. And thank you to those in the audience for joining us today. The questions were great. Reach out if you'd like to further discuss your circumstances, your specific questions. We'd be happy to discuss over a consultation. In the meantime, stay well. Thank you so much.